Hi, my name's Hannah Ranson and I'm from WebGov Consulting, which, as the name might suggest, is a web governance consultancy firm. I've been asked to prepare a brief presentation for you about terms of service agreements. My presentation aims to provide you with the necessary knowledge to develop a terms of service agreement that will be suitable for the online teen learning community currently being developed by your library. The presentation will cover the following points, with a focus on the unique governance issues presented when developing a service for a teen audience. First of all, we'll look at what a terms of service agreement actually is. We'll talk about why you should have one and what it should include and why. And then we'll conclude with some recommendations for the organisation. The presentation is based around the current academic and trade literature, so if you'd like to read further on the issues, any resources that I've quoted are listed at the end of the presentation. All of us have experience of terms of service agreements, also known as terms of use, or simply TOS. In fact, it almost seems that every new website you visit asks you to agree to terms and conditions before you can proceed. That little box that you check without thinking when you create another new account with a web service is a TOS. They're so common, in fact, that most of us don't even take the time to read them before we agree. In legal terms, though, it might be the most important page on your website. So what is a terms of service agreement? It outlines the rules that a website user must abide by when using an online service. What it includes will depend on the nature and purpose of your website and the ways in which users can interact with it. We'll explore content in more detail shortly. Provided that your terms of service doesn't violate local or federal laws, it is a legally binding agreement between the user and the service provider. However, there's currently no legal mandate in Australia for the inclusion of TOS on websites. So if it's not a legal requirement, why would you bother going to the trouble of writing one? Well, according to Jonathan D. Frieden, a well-drafted TOS can assist the organisation in managing user expectations, avoiding or mediating disputes, and limiting legal challenges. By outlining expectations around user behaviour, intellectual property, and the protection of other people's information, your TOS can also protect your users from potentially sticky legal situations. This might be particularly important when your target audience are teenagers. A 2011 Monash University study examining teenagers' awareness of the legal risks of using social networking sites found that while students had an awareness of well-publicised risks, like unwanted contact from strangers and cyberbullying, very few had considered other legal risks, like intellectual property breaches or defamation. Worryingly, only 3.2% of participants identified concerns relating to privacy or unwanted disclosure of their own information as a risk. So a well-drafted TOS is essential for you as developers of an online community for teenagers. So if you want to give your organisation and your users the best possible protection, what should your TOS contain? Many organisations use pro forma policies, copied and pasted from other organisations, or built using online policy generators. Landy and Batista, in their comprehensive 2008 digital legal text, make the case that this is a good starting point, but it should only be the first step in the process of drafting your own agreement. To be truly effective, a TOS should be written with your particular organisation, website, and users in mind. Frieden outlines 6 essential elements of a TOS. He talks about mutual assent, permitted use, intellectual property, limitation of liability, a privacy policy, and governing law. Make sense? I didn't think so. And if it sounds like jargon to you, imagine how it will sound to your teenage audience. Waters, Levin and Valk, in their study of social networking sites, TOS, argue that much like the terms I've just thrown at you, terms of service are too often written in opaque jargon designed to favour the organisation and offering little protection to users, who are the fundamental element of any online community after all. So let's explore how we can incorporate the necessary elements in a way that is beneficial and comprehensible to both your users and your organisation. We'll talk about mutual assent first. So mutual assent refers to the agreement between two parties to adhere to the terms of a contract. In this case, that's you as the organisation providing the web service and your users. Obviously, in a digital environment, parties to a contract are unable to put signature to paper. So generally, assent is expressed in one of two ways. These are referred to as browse wrap and click wrap agreements. A browse wrap TOS presumes agreement on behalf of the user through their use of the service. You might see this expressed on a website through a statement such as, "By using our service, you demonstrate the agreement to our terms and conditions." Alternatively, a click wrap agreement requires that a user click a button, check a box, or in some other way demonstrate their agreement, usually as part of the registration process for the service. There are debates in the legal literature around whether a browse wrap agreement would be held to be legally binding by a court of law. Click wrap agreements are the more common form of TOS for web services that require registration, like social networking sites and online communities. So let's assume that your terms of service will be in the form of a click wrap agreement. In Australia, click wrap agreements are likely to be considered legally binding on adults, but the situation is slightly different for people under the age of 18. Deswort, Lindsay and Henderson, in their study of teenagers and social networking sites, point out that under common law, a contract entered into by a minor is voidable. In spite of this, they advocate for TOS as they establish the terms of the relationship between the service provider and the user, and the rules and expectations associated with use of the site. They also point out that it is important for teenagers to become familiar with their legal obligations when interacting in online spaces, and to understand that these spaces are not unregulated, but are governed by often complex legal systems. Permitted use is perhaps the most important element of your TOS. Permitted use outlines for users what they can and cannot do when using the website, and the actions that may be taken by the web service if the permitted terms are violated. Permitted use vary greatly in length and complexity from web service to web service. For instance, Google's permitted use terms consist of one paragraph, as you can see on your screen. In contrast, the photo sharing site Instagram lists over a dozen rules that must be complied with, along with requiring that users comply with the Instagram community guidelines. Another document outlining rules and expectations that's pretty lengthy by the short, snappy standards of the internet. Perhaps the best approach is to strike a balance between the simplicity of the Google TOS and the complexity of Instagram's. Consider how you'll moderate your community, how you might censor content. Although one author does make the case that when considering the censoring of content on social networking sites, once we entrust the social media corporations to make morality decisions, we can end up having controversial topics, or even non-controversial topics, taken right out of the public discourse. So where you'll draw the line on what is and isn't acceptable content is something you'll need to consider as an organisation, and your decisions will need to be explicitly stated in your TOS. The Victorian Department of Education and Training has developed a range of resources for use in schools that might be adaptable for your purposes. This includes an acceptable use policy that provides a sound basis, written in plain English, and which could be modified to reflect the needs of BookBook's online learning community. It is important to provide conditions for regulating behaviour in online communities, both to ensure the safety and well-being of community members and to help the community achieve its mission. In this case, to support the learning of your teenage audience. There are many means other than TOS of regulating behaviour, and indeed many communities eventually become self-regulating. These are outside the scope of this presentation, but the important point is that it's essential to have an explicit written agreement that establishes the behavioural expectations for participants. So we'll move on to intellectual property. Intellectual property in the context of your TOS outlines the treatment by the web service of user-generated content. Your IP statement should cover who owns the user-generated content. Is it the user or the service provider? If the user owns the content, what rights are they granting the service provider in relation to their content? You need to cover how you intend to use the content, if at all. And finally, you need to outline how you'll manage disputes where a third party claims that content infringes on their intellectual property rights. In recent times, there's been a backlash against many of the larger social networking sites' IP statements. Consider Facebook as an example. The statement on your screen essentially grants ownership of content to the creator, while reserving the right to use that content for Facebook's own purposes, until such time as the content or account is deleted. This is concerning for a number of reasons. Teenagers, who generally don't read the terms of service, might be unaware that their content could be used for a variety of purposes, including commercially. And more worryingly, from an organisational perspective, are concerns that repurposing user-generated content by web service providers might actually be a breach of complex copyright laws. So perhaps the best route to take, both from the perspective of protecting user rights and protecting your organisation from potential legal action, is to leave content ownership and reuse firmly in the hands of your users. It will also be important to consider how you'll approach the issue of your users posting content that they haven't created, particularly given the nature of your audience. The statistics on screen give you an indication of the rate at which Australian teenagers, are posting content created by other people. According to the survey, very few of the students surveyed had an awareness that by posting other people's content they might be infringing copyright laws, with not a single student out of the 1,004 students surveyed mentioning copyright infringement as a potential risk of using social networking sites. You'll need to clearly indicate to your community members what constitutes copyright infringement and what action will be taken by you as a service provider if infringing material is posted. So let's talk about privacy policies. Although listed here as part of your TOS, the privacy policy should be published as a separate document, easily accessible to users. Generally, privacy policies are presented as browse wrap agreements with a link in the footer of every page on the site. So how is a TOS different to a privacy policy? According to senior commercial lawyer Dana Prasek, a privacy policy outlines how a web service will collect, store and use customers' personal data, while a TOS sets out rules and regulations relating to the customer's use of the web service. And why would you have a privacy policy? Well, the answer to that question is a little bit more clear-cut. If you're a public sector organisation collecting personal data, then you're legally obliged to comply with the relevant state or federal privacy legislation. In the case of Book Library Service, that's the Victorian Privacy and Data Protection Act 2014. Complying with this legislation and outlining your compliance in your privacy policy will ensure that you A, make provisions for the responsible collection and handling of your users' personal information, and B, make provisions for breaches of an individual's information privacy. This will protect both your users and you as an organisation. For more information on how to write a privacy policy that complies with Victorian legislation, visit the website of the Commissioner for Privacy and Data Protection. So finally, you'll want to express your limitation of liability and indicate which state's laws govern the TOS. Limitation of liability allows you as a service provider to limit the amount of loss or damages that can be claimed against you. Limitation of liability must comply with applicable state laws and will be one part of your terms of service that you'll be more than likely to seek legal advice for to ensure that you're appropriately protected. Governing law is an expression of which jurisdiction's laws will govern the enforcement of the TOS and where any disputes will be heard. In the case of Book Library Service, this will more than likely be the state of Victoria. So, by including all of the elements outlined so far, you should have the makings of a comprehensive terms of service agreement. Based on this information, I have some recommendations for the organisation, primarily around the communication of the policy to your users. I recommend that you use a click-wrap agreement. Click-wrap agreements are generally recommended because the fact that a user has indicated their assent to the terms is more likely to hold up in a court of law. Given the age of your audience, as we've talked about, there is a chance that if it came to a court case between your organisation and a user, the contract would be considered void. But using a click-wrap agreement is best practice and will hopefully result in more users reading the TOS, which will make for better informed users, a bonus for both your organisation and your community members. I also recommend that you include a browse wrap style TOS where a link is placed in the footer of each page, along with a link to the privacy policy. This will ensure that your users can quickly access the information when they need it. My final recommendation is around the language that you use to communicate your TOS to users. A 2010 study by Sumit Singh and Miller found that at least 20% of online privacy policies required a postgraduate education to read, with many others requiring a second and third year university reading level to comprehend. And I would argue that terms of service agreements are often equally as incomprehensible as privacy policies. So is it any wonder that most of us never read them? The authors also point out that the average reading ability of the population is set to decline, so our current legal jargon will become even more incomprehensible to the majority of the population. It's essential then that we present information in the language that users are familiar with, or we don't stand a chance of helping our users to know their responsibilities and protect their rights online. I'll leave you here with a set of 14 guidelines that have been developed based on extensive research for drafting online policies and agreements that are comprehensible to young people. These guidelines cover the necessities for language, structure, and design, and will be equally applicable to your terms of service agreement. So I've provided you with the basics that you need to get started on drafting a terms of service agreement that your users will understand, that will protect you as an organisation, and that will also help your users to be more aware of their responsibilities and rights in online spaces. So good luck, and if you have any questions, please don't hesitate to get in touch.